Hello, my name is Tom Goldman with Goldman & Laughlin, an immigration law firm. I decided to make this particular video about the immigration bond process after receiving a call from a lady who was obviously stressed. Her husband of 12 years and father of her daughter had been arrested and detained by Immigration and Customs Enforcement. She was desperately trying to find a lawyer who would explain the process her husband would go through, the options she had, and how long the process would take. Of course, most importantly, she wanted to know if he could get out of jail on bond, and would he be able to remain in the United States. Her problem, she said, was that she could not find a lawyer to talk to her without an upfront fee. So this video is for all of you who have had someone detained and you just want some information so you can begin helping your relative or friend. Hopefully we can help you understand the process so you can make an informed decision before spending a lot of money. Obviously, this is not intended to be a substitute for you hiring an attorney to advise you about your particular case. Each case has to be examined carefully by a lawyer before you make any final decision about what you should or should not do. So with that introduction, let me start with a few basics. The foreign national may be sent to a local facility within your state, and sometimes more than one facility, before finally being sent to a place where an immigration judge can review the case. In some cases, the foreign national may be sent out of state, but most of the time that is not the case. This process takes time, so the family has to be patient and know that it will take 2 weeks or longer to have a court hearing. It is best to contact an attorney immediately after the foreign national is detained, but sometimes that is not practical because it takes time to raise money for the representation. Don't worry about the first hearing. If an attorney has not been hired by that time, the judge will set another hearing and give time to hire an attorney. In order to establish communication with the foreign national, look up the detention facility's website and you will be given directions about how to send money for telephone calls and information about visitation. When you are able to speak with the detained person, ask if any paperwork has been given by the immigration officer. If so, ask for the alien number or a number on the paperwork. Your attorney will need this information. You can also provide information to the detained person about the attorney you have hired or hope to hire. The process is basically divided into two parts. First, is the foreign national entitled to bond, or will he or she have to remain in detention until the final resolution of the case? Secondly, is there any relief in the case? In other words, is there a legal way for the foreign national to remain in the country? Let me first deal with the bond. There are situations where bonds will not be available. This would include cases where someone has multiple criminal convictions that are considered crimes of moral turpitude, or a conviction of even one such crime if the potential punishment could have been more than 1 year. The term crime of moral turpitude is one that requires a legal analysis since courts have struggled with the definition. This is where you need to let your lawyer determine if such a crime has been committed. However, the immigration paperwork the foreign national received will let you know if the government believes this type of crime has been committed. Also, if there has been a conviction for drugs or firearms, a bond will not be issued. And finally, crimes which are considered to be aggravated felonies will prevent a bond from being set. Again, let your lawyer decide if any crime committed is an aggravated felony. There are other crimes which will prevent bond, but the point is that no matter how good a husband, wife, or father the foreign national is, in some cases there will simply be no bond. If the foreign national is not under mandatory detention, the Department of Homeland Security, Immigration and Customs Enforcement may set a bond. If so, you should pay the bond in order to be released. In those cases, however, when the bond is too high or has not been set at all, then you may request a bond be set by the immigration judge. It is also important for the lawyer to determine if any relief is available. For example, a person may be married to a U.S. citizen and be able to apply for adjustment of status by virtue of this marriage. Or for people who have been in the United States for more than 10 years, has no serious crime, is a person of good moral character, and can show an extreme and unusual hardship on a spouse, child, or parent, the person may qualify for cancellation of removal. For people who are lawful permanent residents already, cancellation or removal is also available, but the requirements are less strict. Deferred action is another form of relief. There are two types of deferred action. The one that came out first is called prosecutorial discretion, and the intent is to allow people who are low priority to have their immigration cases administratively closed. A low priority case involves members of the armed forces, people who came to the United States when they were young, victims of serious crimes, those who have medical conditions, and people who have been in the United States for a very long time. On the other hand, a high priority case would be one where the person has criminal convictions, someone who's a gang member, those previously removed from the United States, those who entered the United States within the last 3 years, and suspected terrorists. The second type of deferred action is referred to as Deferred Action for Childhood Arrivals, or DACA. There are several requirements, but generally, the child had to enter the United States under the age of 16 and was not 31 as of June 15, 2012. Residence for at least 5 years plus a high school diploma or a GED are also required. Special attention has to be paid to any misdemeanor or felony charges. There are other types of relief available, but a number of factors will determine if a person is eligible for a form of relief. The judge will consider whether or not the person is a flight risk or security risk. Most cases revolve around the issue of whether the person is likely to show up at future court hearings if released. This is where you come in, because the court will consider family ties in the United States and the employment history. By helping the attorney gather evidence such as birth certificates, letters from employers, family and friends, a lease agreement or real estate deed and mortgage, and other records, you can increase the chance of success at a bond hearing. The court will also look at the extensiveness of the criminal record, any failures in the past to show up for court, and other negative events in the foreign national's past. If bond is granted, the lowest bond the judge can allow is $1,500. Or $500 if the person is taking voluntary departure. And this can be paid by anyone for the foreign national, or a bond company can be hired which will post the bond for a fee. The bond has to be paid in cash, money order, cashier's check, or U.S. bonds or notes. To post bond, contact the detention facility where the foreign national is being detained. You can find the detention center on the Immigration and Customs Enforcement website at www.ice.gov/detention-facilities. Each facility is listed and has directions concerning how and where to post the bond. The person supplying the bond money must show proof of identity and lawful immigration status. This person, the obligor, is responsible for ensuring that the foreign national presents himself before an officer or agent of this agency whenever a request is made. We recommend that you call the facility and speak to the deportation officer handling the case or the person designated to handle the bonds and make an appointment, if appointments are taken. You will need the alien number when you make the call. Bonds may be posted between 9 o'clock a.m. and 3 o'clock p.m. Monday through Fridays except for holidays, and you need to allow 1 to 2 hours for the process. Generally, payment is made by certified check or money order, but the facility will state their preference. Be sure to keep the receipt for paying the bond and to notify Immigration and Customs Enforcement of any change of address for you, because once the case is completed and the foreign national has not breached the bond, a refund will need to be made to you, or if the bond has been breached, a notice will be sent to you. Refunds can be made once the bonds are canceled by contacting the Debt Management Center in Williston, Vermont. If bond is not granted, the hearings will be held at the detention facility. But if bond is granted, the case can be moved to an immigration court, possibly closer to home. The goal, of course, is to have the family member in detention return home as soon as possible. Bond cases are emotional situations because obviously the family wants their loved one to be released as soon as possible. However, it is best if only one person, either family member or friend, contacts the lawyer and handles all communication with the lawyer. This avoids numerous phone calls with people hearing different things at different times. Also, as I mentioned, the family needs to be patient and rest assured that the court will move as quickly as it can to conduct hearings and make a decision in the case. I hope this helps you understand the system a little better so you can make informed decisions early on in your case. If you have any questions, you can reach us at one of the numbers on the slide or contact us at our website, www.usimmigrationteam.com.